Okay, so this is my response. The defendant's motion to quash the City of Natchitoches motion in limine to preclude publication of witness video and audio statements and for the production in-camera inspection. May it please the court, the defendant Travis Hines moves to quash City of Natchitoches motion in limine to preclude publication of witness video and audio statements and for production in camera inspection insofar as it is not timely filed, denies the defendant of certain rights and procedures, and may be moot as a suppression hearing should be held prior to any other hearings. On February 9, 2022, the defendant filed a motion to suppress and requested a hearing. This court set a suppression hearing on March 23rd, the same date that this court set the trial. The City of Natchitoches has set a hearing for this motion on March 21st. The issues raised in the city's motion in this matter may well be moot based upon the defendant's suppression hearing. The information raised in the city's motion brings to light evidence that the city did not provide the defendant as ordered in defendant's motion for discovery and motion for bill of particulars. The City of Natchitoches alleges arguments that have not been introduced into evidence and contends that the allegations made by the city are fact. These are allegations and have not been decided by a trier of fact. The allegations made in the city's current motion are specifically in question in defendant's motion to suppress. The city's prosecutor is introducing new evidence that was not made available to the defendant in discovery. The new evidence is only being made available to the defendant 2 days prior to trial and does not allow the defendant time to prepare for his trial, nor does it conform to the criminal rules of discovery, which must be provided to the defendant more than 10 days in advance of the trial. The defendant has never, either directly or indirectly, intimidated or harassed any witnesses, court personnel, city personnel, or other officials. This defendant has a First Amendment right to broadcast and disseminate information, and especially information of public matters and public concern. The defendant is a professional member of the media and owns a broadcasting channel on a publicly accessible media platform, YouTube. The city prosecutor alleges new felony charges against the defendant for exercising his First Amendment rights. The defendant has no legal culpability to the actions of any viewers of his content and has never applied or directed the viewers to take any action toward any witnesses, officials, or personnel. The inclusion of the felony charges stated by the city prosecutor has only one purpose: to intimidate the defendant. It is outrageous misconduct that a court official would attempt to intimidate a defendant in this way. I ask the court to take judicial action based upon this conduct against the city prosecutor for this intimidation. There has been no notification to the defendant of any disruption of process caused by his dissemination of public information. The defendant has not frustrated the process of the proceeding, and any member of the public at large is neither under the control of the defendant or the court's jurisdiction. The court can set parameters that the defendant not publish certain information, which the court can hold the defendant accountable. The city prosecutor has the opportunity to bring this matter before the court when the defendant filed his motion for discovery and motion for bill of particulars. The city prosecutor did not raise this issue and chose instead to bring the matter just 5 days prior to trial and hold the hearing just 2 days prior to trial. The city alleges that extraordinary circumstances exist in this case. However, the city prosecutor has not once contacted the defendant about this or any other matter in this case. The defendant has a state of Louisiana constitutional right to evidence proffered against him in trial. The defendant has not posted any personal information of officers, witnesses, court staff, or other city officials. The defendant has taken extra steps to specifically redact personal information of officers supplied to the defendant by the city prosecutor. Therefore, the allegations made by the city prosecutor in this matter are unsubstantiated. The defendant has complied with all orders of the courts. There is an inherent difference to a civil trial and a criminal trial. The city prosecutor's suggestion that civil procedural functions should simply be held to criminal procedural functions is not a simple matter at all. Defendants in criminal cases have a magnitude of rights which are not afforded in civil procedures, and sealing court documents to be used against the defendant from the defendant is not permitted in this country unless the defendant is incarcerated for a felony crime. The defendant in this case is not incarcerated and has no felonies. He is a former military police officer and was honorably discharged. The in-camera inspection by the city prosecutor should have been timely made when discovery matters were heard by this court on February 15th. Any additional discovery should have been made prior to 10 days before the trial. The filing and hearing in this matter were done in 5 days and 2 days respectively. On this ground alone, this motion must be quashed. Wherefore, the defendant respectfully requests that the City of Natchitoches motion in limine to preclude publication of witness video and audio statements and for production of in-camera inspection be quashed. And then this is the order for Judge Owsley to sign. Okay.